Judge, Mr. Marco had apparently made arrangements to appear by Zoom.
Oh, there he is. Okay. Okay, great. This is docket 20262NO. Joel Stockford versus, so is it Soda Magic?
Sedesco Magic.
Sedesco Magic, I should know that by now. Sedesco Magic LLC and the Chrisman Company. Counsel, your appearances for the record.
Good afternoon, Your Honor. Allie Ferris on behalf of the plaintiff.
Michael Bryant on behalf of Sedesco Magic.
Good afternoon, Your Honor. Chris Nineheis on behalf of the Chrisman Company.
All right, thank you.
Your Honor, as a preliminary matter, before we start arguing, with respect to the motion that was continued today regarding Dr. Schuette's neuropsychological examination and testing, you had requested an offer of proof. I've spoke with Ms. Ferris, and they have agreed to my proposed order with respect to that. I don't have Mr. Miller's signature on it. He indicated he was waiting to hear from Mr. Marco. They have agreed to it. If I can approach.
You may, I like that. Thank you, sir.
There's copies there as well.
Oh, great. You have my stamps or no?
Not in here.
You'll just take a second. I'll sign this. Thank you. Counsel, you may approach. I have 3 copies for you. We kept 1 for 5.
Thank you.
Thank you. All right, great. Next matter.
Good afternoon, Your Honor. Here on our motion to amend.
All right, you may proceed.
Good to see you again so quickly after introducing the matter last week. I think this was somewhat previewed in that discussion of Chrisman coming back into the case after 3 years of absence. So this motion was actually pending the last time we were in front of you. We would like to amend our complaint to reassert our claims against Sedesco Magic and Shaw Winkler. I would also ask for permission to extend the deadline to amend. We're considering, now that things have changed, adding Lake State Insulation, which is
What installation?
Lake State, which was the plaintiff's employer. To address the arguments, this is kind of the second time I think in 2 weeks that I'm effectively arguing a summary disposition motion without the benefit of a summary disposition process. And frankly, I think the court is kind of in the same boat as me, where everything's coming in at once, a little bit on the fly. But I'll start with Sedesco's opposition to the motion. The basis for their opposition is futility. And again, we're basically arguing summary disposition right now on the futility issue. Their position is that there is no claim for common law indemnity because Chrisman is alleged to have been actively negligent with respect to this case. My response is that the allegations with respect to Chrisman are that it failed to do so, as opposed to actively being negligent with respect to the cover on the fan guard. And so while I understand the point about an allegation or showing of active negligence, that's not how Chrisman is being brought in here. It's because Chrisman apparently failed to do something as opposed to doing something. With respect to plaintiff's opposition, to bring in Shaw Winkler, it's a little strange that they would oppose bringing in the contractor who was actually responsible for performing the work in the utility closet where the incident occurred. They're claiming that, again, it would be futile based on the ruling that was entered 3 years ago on the summary disposition. Because apparently that ruling's good with respect to Shaw Winkler, but it wasn't good enough for Chrisman. Our allegation there is that the trade contract, it's a little different situation than the standard owner GC subcontractor relationship. Chrisman was a construction manager here, which means that the trade contractors, typically a sub, contracted directly with Lansing School, the owner. And so in that contract between Shaw Winkler, who's in charge of the mechanical work, there is a specific indemnity provision that indemnifies Lansing School as the owner and Chrisman as the construction manager. And the idea there, and I can get into the details, but it was, if you tie several provisions together, basically Shaw Winkler is indemnifying Chrisman for anything related to its scope of work. And the work that was performed in the mechanical room, is related to the injury, whether
Let me ask you this.
yes.
We're not going into all of that.
Yeah.
Judge Stokes previously ruled on that. What did she get wrong or didn't she consider so that I should let someone back in who she kicked out specifically?
Well, first of all, I think Shaw Winkler, we're asserting an indemnification claim, which was moot because of Chrisman being let out. So to the extent Chrisman is back in, that indemnity claim is no longer moot.
Okay.
And our claim as it relates to indemnity is based on the contract. And so to the extent Shaw Winkler violated its contractual obligations, among others, they have an obligation to indemnify Chrisman if Chrisman is ultimately found liable for something that Shaw Winkler was responsible for. Because how this works generally, Your Honor, is, as a matter of law, setting aside the exception for common work area, subcontractors.
Setting aside what?
The exception for the common work area doctrine. Subcontractors or trade contractors are responsible for safety of their own work. And so the contractual situation here is that Shaw Winkler was in charge of the safety for its own work, including for portions of the work or areas adjacent to the work. So, there's been argument that the air handler wasn't part of the work, therefore indemnity somehow doesn't apply. But if you look at the trade contract, it was adjacent to the actual work. So if it's found that this is a problem, Chrisman still has an indemnity claim against Shaw Winkler. So, the basis for dismissing the negligence claim against Shaw Winkler is really the same basis for dismissing the negligence claim against Chrisman, because the air handler wasn't part of the work. Was not.
Thank you.
But again, this is an indemnity claim for us to bring Shaw Winkler back in. If plaintiff wants to reassert its claim against Shaw Winkler, that's, I guess, up to plaintiff. But it's not futile.
Okay.
And again, we could brief it later again. And then the next part that the plaintiff complains about is the prejudice to the plaintiff that adding a party in at this point would cause them, I think, because of the delay. And, you know, respectfully, that's not my fault that this is going to push the case out farther. El Jamali, which was the basis for amending or bringing back Chrisman according to the plaintiff, was decided in July of 2024. And the motion to bring Chrisman back in the case was filed about 16 months later. So, you know, if this is going to force trial to get canceled or adjourn and the schedule to get pushed, that's not Chrisman's fault. We acted about as quickly as we could to reset the playing field back to where it was previously. So, you know, basically the plaintiff made a strategic decision to bring Chrisman back in now as opposed to wait for an appeal. And the downside of that is that there will be a delay. It was a choice. That's the flip side of the strategy. You know, I found it somewhat ironic in the plaintiff's brief that they said that it would be prejudicial to Shaw Winkler because they would have to do all this work to get back up to speed because of the delay. Well, the same is true for me. So what's good for the goose is good for the gander. While I appreciate that it may delay things, I don't think that's actual prejudice. That's just a consequence of the strategic decision to bring Chrisman back in three years later and a year and a half after, or almost a year and a half after El Jamali was decided. Happy to answer any questions, Your Honor.
Nope, let me hear from counsel.
Just briefly, Your Honor, I have filed my response, which sets forth my position, I think, which is relatively straightforward, that the cross-claim that's being sought against Sedesco Magic is for a common law indemnity. The only time you're entitled to common law indemnity, which is purely a derivative of any liability that they may have for solely acts or inactions by Sedesco Magic, is if there's no claims of active negligence being made against you. And in this particular case, has been extensively discussed. There's allegations against the Chrisman company that they failed to comply with their contract. They were required to perform site inspections, daily inspections.
Wait, they were required to perform what inspection?
Daily inspections, site inspections, and did not do so. And a purely obvious, visible guard being off of the machine was not remedied by them or requested to be remedied. Those are claims of active negligence. And this is not purely a derivative claim, and therefore any cross-claim for common law indemnity would be futile and should be denied at this time. Otherwise, I'll rely on my brief, Your Honor.
Thank you. Counsel response?
So, Your Honor, we split the motion into two because we don't oppose the cross-claim against Sedexo. Chrisman originally asserted those claims and they were dismissed solely because Chrisman was dismissed. And now, since Chrisman's back in, we agree that those can proceed. On the third-party complaint against Shaw Winkler, we oppose it on the basis of futility and prejudice. It's futile because Shaw Winkler's dismissal was not a close call. After extensive discovery and oral argument, the court had made explicit findings that Shaw Winkler had nothing to do with the air handler, which is on page 45, lines 18 to 23 of the MSD hearing transcript. They found that Shaw Winkler was not negligent and was doing the work that they were contracted to do, and not a single new fact has emerged since then having to do with Shaw Winkler. Additionally, it's prejudicial because this case is from 2019 and Mr. Stockford has been out of work since the day of the incident and has endured multiple surgeries. And bringing Shaw Winkler back in does mean full discovery, motion practice. I'm sorry.
Just a moment, hold on, he's up.
Full.
Shaw he has endured multiple surgeries and bringing Shaw Winkler back in what?
makes full. Go ahead.
means full discovery, motion practice, and inevitable delay, and he can't wait any longer. I guess in response to Chrisman's argument that they were added back in, they are a necessary party to this, and I do want to let the court know that plaintiffs' counsel and my office, we filed our appearance in this case towards the end of September, and we're able to catch up for the last 5 years pretty quickly. And since Crispin's dismissal, the extent of what has been going on is not much compared to when Crispin was still in the case. And Mr. Marco is really insistent about also getting a trial date. The court staff had represented to him that August 28th of 26 is available and would work. So we would ask if the court would be willing to set that as a trial date.
I don't have a problem doing that. And the issue, though, that I think everyone needs to address is what counsel initially addressed on behalf of the defendant about Shaw Winkler may have done everything right. I don't know. Everything I've read said he's not negligent, but if there's an obligation to indemnify, then that's a problem. That would be the reason he gets in, wouldn't you agree with that or not?
Yes, I think that the contract that was referred to is the contractual indemnification fails because Shaw Winkler's contract with the Lansing School District was an express no third-party beneficiary clause, and Crispin's not a party to the contract.
Okay, stop right there. Counsel, can you address that?
Absolutely. Part of the contract was AIA 232.
Was the what?
The AIA 232 general conditions trade contract with Lansing. Section 3.18.1 says, to the fullest extent permitted by law, the contractor here, Shaw Winkler, shall indemnify and hold harmless the owner, construction manager, architect, construction managers, and architects, consultants, agents, and employees against claims.
What employees?
Apologies.
It's okay. I just.
Employees of any of them from any claims, damages, losses, etc., in any way related to performance of the work or the duties or obligations of this agreement, and it goes on. So that's an express contractual provision. There's also something in the trade contract between Shaw Winkler and Lansing that says, for safety, it refers again to this A232, says in addition to the requirements of the contract general conditions, trade contractor acknowledges receipt of construction manager's safety program. The trade contractor agrees to cooperate with the owner and or construction manager safety program to take all reasonable precautions for the safety of its employees on the projects, to assist in the prevention of accidents or injury to persons on or adjacent to the premises where the work is being performed. So within the contract, it clearly covers Shaw Winkler. It provides an indemnity obligation specifically towards the construction manager, which is typical in these construction manager as advisor contractual frameworks.
And ma'am, do you disagree with that?
Give me 1 second going through my motion to pull it up, because we have in the contract, it says no third-party beneficiary clause, and this agreement is not intended to create any third-party beneficiary or duties or rights to third parties.
She's got to slow down.
Sorry, on Zoom.
Oh, sorry.
It's not your fault. In court, you'd probably be just fine, but Zoom is a little bit tricky sometimes. So where should she pick up?
Hold on. No third-party beneficiary clause is towards the beginning.
Okay. So Shaw Winkler's contract with Lansing Schools has the express no third-party beneficiary clause, which states this agreement is not intended to create any third-party beneficiary or duties or rights to third parties and is only for the direct benefit of the owner and the trade owner. Chrisman is neither the owner, that was Lansing School District, nor the trade contractor, which was Shaw Winkler. So under Brunsell versus City of Zeeland, ZEELAND 467 Mish 293 at page 297, 2002, and MCL 600 1405, parties may expressly disclaim third-party beneficiary status, and that disclaimer is enforceable. Notably, Chrisman's own 2023 briefing conceded that this was a problem, calling it wisely not addressed in Shaw Winkler's MSD brief.
Response?
I didn't concede anything about letting Shaw Winkler off the hook for indemnity obligations, Your Honor. The contract specifically includes something for indemnity for the construction manager. Shaw Winkler didn't even make this argument when we were in summary disposition, and that's what the footnote she's referring to actually means.
So here's what we're gonna do. We're gonna be on an expedited trial track. I'm going to order Shaw Winkler in. I can always order him out. But it seems to me there's a dispute. When there's a dispute, it tells me that I need to look further into this. Maybe he'll be let out, maybe not. But I've heard enough to reconsider what Judge Stokes did, and I know she found there was no genuine disputed material fact. However, it looks like maybe it's a contractual interpretation along with the case law and the statute that I need to look at. So for now, they're in, and we have to change the discovery. I need everything turned over, emergency style, because I do not want to change the trial date. I would agree with the plaintiff. They've waited long enough.
All right. First of all, Your Honor, Judge Stokes did not rule on our indemnity claim, other than to say that it was moot.
Okay.
Second, with respect to trial date, are you referring to the June trial date?
I'm referring to the August one.
Okay.
Is that enough time?
I don't know what I don't know in this
And I
case
don't
yet.
either, so.
Because there's
You can
been,
stop. You can give me good cause to move it, but right now it's aimed toward August.
sure. The cause right now is that there are close to 200 docket entries that were part of this record since we were dismissed.
Yeah.
All I know from that is that the plaintiff has been deposed since we were out. There've been trial depositions. I don't know what experts are actually involved here. I need to get that stuff evaluated and know what I have to do. Second of all, Your Honor, plaintiff's basis for bringing Chrisman back in was apparently a fundamental change in the law. If that's true, I need to reevaluate everything because I was trying a case or doing discovery for a case aimed at a pre-Jamali world, which according to the plaintiff is completely and fundamentally changed.
Okay.
So without having received what's been exchanged in the last 3 years, I can't commit to evaluating discovery, doing discovery factor expert, and prepping for a trial in August.
Well, let me just say, I feel your pain, but plaintiffs waited a long time. So what you need to do is get all the information. I'm gonna order everybody, expedite getting everybody the information, so you can all start having meetings, case eval, mediation, depth, whatever it is you need to do. And if I need to move the trial date, so be it, but let's stay on track. I don't want to give you some date in 2027 and then everyone thinks they have time, because we don't. I'm in your same boat. I have to order some transcripts because I got to get to the bottom of some of the things that you did early on 3 years ago that I don't have any idea. I want to say I've read every word, but I keep getting motions like this. So, I have this, maybe not as much work to do as you, but I've got a little bit more work to do as well. So everybody's gonna feel the pain. Let's just stay on top of it. And, I only have so many trial dates, so I'm giving you some. And holding it until we find out we can't do that, and then we'll move it a few more weeks or months, but let's move it on a can-do basis rather than not on a can't-do basis. You can work magic if you want. I don't want you to put your license on the line. I truly understand that. I was a practitioner. I get all this, but I want everybody to be working hard for resolution of this. So how can I help?
Well, Your Honor, we could push it beyond August with my next 2 months taken up by what would be a 2-week, 3 weeks in arbitration in Chicago that I've been taking all my time. And
Well-
I certainly didn't see this one coming back from the grave.
I
3 years ago.
understand.
And then we're also gonna have Shaw Winkler that's gonna be in here. And according to plaintiff herself, there's gonna have to be discovery and motion practice. And it's the same for us too. So I would say August is, I don't know if that's possible with with discovery and motion practice and a new party.
Okay, I don't
And
either.
interim deadlines, I would need, the entire schedule would need to be rejiggered so that there is additional discovery. I would
Okay.
want an additional motion practice, dispositive motions. And
Okay, well, I'll tell you what. I'm not gonna move the trial date until you all get together and figure out the discovery. Based on that, I'd be willing to move the trial date. Right?
yes, the complicating factor is that there's somebody who's gonna participate in that who's not in here yet.
Right. So we need them invited in, we
Yes.
need all of these other pieces of paper, and then we'll have a meeting, and if you all need me to have monthly status conference meetings with you, I'm happy to babysit this file.
I appreciate the attention that you will give it here.
I will be, well, I have to learn it too. I mean, this is very complicated. When I start reading it and start pulling a file from here and a statement from there, and then a code, and then a statute, and then a case. Believe me, it's not my expertise, so I have to learn it with you. So I understand the frustration, but you've got an obligation to your client, but let's start with discovery, the scheduling order that you all can come up with, right? The new dates, and then let's work from there, because I don't want to just keep handing out trial dates. So I'm gonna leave this one. You tell me it's impossible because of discovery, because of depth, because, I'm happy to move it. I'm reasonable.
Sure.
But today I'm not moving it because I also know that attorneys work toward trial dates. I was one. I know what I could put on the back burner and what I couldn't. So we're gonna keep that, get a scheduling order, get all your minds together. If you can't agree on a scheduling order, I have a conference room. You call me, we'll fit you in on a date. I give you my lunch hour or my whatever.
I appreciate that, Your Honor. Just for clarity, I know coming up, there is a mediation deadline of April 15th.
All that's gonna be
Adjourned.
moved, sir.
And there's also a site inspection that was apparently was noticed for March 16th. I don't even know what experts I need to be at that because I don't know who their experts are at this point, so I would ask.
Okay, so move it all. Agree,
Yes,
agree, move it all. Scheduling order, I'll move it all.
very good, just to be clear.
Okay, you all get together. You need me, I'm there. You need me to be with you to do the scheduling order, that's fine too. Do you want me to set a sort of review date or what?
I would appreciate that. Yes.
Okay, so how long do you all think you need? Or do you want to do the scheduling order with me, or can you do it before me and then we'll meet, or what?
I would say we should take a stab at it between all of us. Once I get Shaw, and I did give Shaw Winkler notice of his hearing. I've been trying to keep them apprised of what's going on. So I will try to work with them as well on schedule, letting them know what's happening today.
Okay,
Otherwise, I would say in the next 2 weeks, the parties would be able to do that. I just don't have it.
okay.
And it may be that we need the judges involved in that.
Let me see. Can you all meet March, you want the 18th or the 25th?
John and I start trial on the 24th, I think. So the 18th would work best for us.
Okay, the 18th, let's just meet at noon. Well, let's say 12:15. I'm gonna have to get rid of my criminal docket and be done by 12:15. They might have to move a few things. But the 18th at 12:15, I'm gonna give you an hour.
It is now me, Your Honor, it'll be Sunday for my so.
That's fine.
Doesn't
You
work.
can always zoom in too. We're used to having some Zoom in the conference room. If something, you can send someone, you can also zoom in. So as long as we can get the work done, I don't care.
The last 2 weeks of March are expert depositions for myself, getting ready for the state.
Okay.
So
So I'm just gonna call it a scheduling / miscellaneous, hearing or whatever. We're gonna do it in the conference room, and it's going to be March 18th at 12:15. All right, anything else?
Yes.
Okay,
With respect to the motion as to this Sedesco, the filing of the cross claim,
yes, granted,
that's granted.
it's granted.
True.
I'm granting everything. We're sort of starting over because once, I don't know how to not grant that when I'm letting all these people in, when we're sort of starting over, but we're not. So we can always let people out. We can always change whatever, but I'm just letting it all in. We're going to re-sift the sand, okay? I don't know how it's going to land, but I think in all fairness, there's been enough time, enough party shifting. A lot has gone on here. Hopefully it doesn't go to another judge. God willing, I'm still here. But you all have gone through this and I apologize. It should not have happened this way, but it did. And so now let's get a handle on it and keep moving forward. And I seriously, if I need to meet with you every month, we need to have a hearing time every month, let's do it. I am known for that.
Yeah, just the other clarification, Judge, and I appreciate what you have to say. The inspection for March 16th is going to be postponed, and the trial that was scheduled for June 1st is postponed to a current date of August 28th.
Subject to change.
Which is subject to change. I just wanted to be clear on that because it's an upcoming inspection that we need to postpone and
Yes,
trial June 2nd, so I just wanted to be clear.
yes. But
Thank
let's do a reasonable scheduling order we can maintain for everybody. And then reasonable motion times and make sure these are complicated and I don't know, I'm gonna have to tell my staff we probably need 2-hour blocks each time because they are long. So it might be we're not doing it on a Wednesday, but we're doing this on a Friday afternoon like we are now, or a Monday afternoon or what have you, because Wednesdays are too short for us, I think.
Thank you, Your Honor.
Thank you.
thank you, Your Honor.
Have a good weekend.
Thank you. You too.
And then, did you tell Sophia?
Yeah.
Adam?
I already messaged them.
I don't know if they read the message. They respond. Adam, Sophia? Can you hear me? We've moved your case over for a couple of weeks. Contact the attorney, please.
Is somebody even in there?
Oh, they just left.
Oh.
You sure